Okay, I'm trying to pause it.
Current events and logic, they are developing their rhetorical critical thinking skills with this trial exercise. By struggling through this case with all the dilemmas and various scenarios, they have encountered our judicial system, an imperfect system. Our tutors hope to help students see that there is truly only one perfect system, one perfect and just judge, and our one perfect deliverer of justice, God the Father. This is the focus of our mission in classical conversations. Although competition is not the main focus, it is a critical element of this experience. It's to be enjoyed and anticipated by all. We expect it to be healthy and in the right spirit, and learning the process has already been very productive for the students as they are prepared. We all like to win, but the primary focus of this process is the process itself. Our presiding judge will, as a matter of courtesy, render a verdict. However, this is done so purely for the purposes of education and satisfaction of curiosity. Since the objective of mock trials is not to carry out justice, but to teach and reinforce rhetorical and public speaking skills, we expect good sportsmanship and Christ-like integrity. Proper decorum is expected and required. The students have worked very hard to get to this point, and we are proud of them all. This is their time to shine. Now the rules of the trial. All trials will be governed by the rules of the Classical Conversations Mock Trial League. At the end of each round, the jury panel will assess and award points based on performance of each individual. Our judge will assess each team's presentation and award points on overall team performance. He may also provide a verdict at the end. Any grievances will be written down on the legal pad, which you have in front of you. It's either a small pad or a legal pad, but there's one there. Place it in the grievance envelope, which is there as well. And I will collect them at the end of the day. At the end, one student from each team, a grievance representative, may be asked to confer with me, the administrator, concerning any grievances. The administrator may levy a maximum of 20 points based on any violation of the rules. The determination of which team has won is based solely on these points, and it is final. Now then, rules for the spectators. You must remain in the spectator section behind the bar, as you are right now. You must not talk, signal, communicate with, or coach any team member. Please turn off your phones, Blackberries, texting, or other devices. Computers are allowed, provided there's no internet communication. Spectators are to have no communication with the administrator, me, during this trial. Spectators are not to talk to students until the very end, and when I announce the results. To the judge and jury, do you have the correct forms that are necessary for this trial? I do. All right. I think you all are all well aware of where the restrooms are, should they be needed. Do you have any questions of me before we begin? Then we'll have the opening. You may begin.
Let me make a few remarks before we actually begin the trial itself. This is an actual courtroom where the lives and liberties and property of people are decided by juries, by courts. There is a lot of technical equipment in this room, and they've had moot courts in here before where some of the participants have touched the equipment or played with it or whatever. Do not, and I warn you, do not touch any of the technical apparatuses that you find around this courtroom. Just resist that temptation. I know we all like to experiment and see whether a computer works or something like that. Don't touch it. We want to welcome you to this courtroom. This is a courtroom that's located in the 18th Judicial District, which includes Seminole and Brevard County. It is a circuit courtroom, which is the main trial level that you'll find in the system. From here, if somebody is unhappy with a decision that a judge makes, they can appeal it to the 5th District Court of Appeals, which is located in Daytona. It's a court that I served on for 10 years. I've been a lawyer or judge for 48 years, so all of this is, doesn't bother me much at all, but I know that the first time I was in a courtroom, I was scared to death. And I'm sure that a lot of you are nervous about it, but just relax, take a deep breath, step back, and you'll be fine. This is not something where it's life or death. We want you to learn from this experience, and if you get too uptight about it, your learning ability is going to be curtailed. So just relax, enjoy it. Nobody's going to throw you in jail or find you guilty and haul you off in chains or anything. So just relax and have a good time and enjoy what goes on here today. This is a criminal case from what I understand. And let me just tell you what normally happens, and I'll just take a minute to do this. But the criminal trial would be conducted much the same way that this is. There would be opening statements made, there would be witnesses examined, there would be evidence presented, there would be closing arguments to the jury, and the jury would then retire to the jury room, which is behind this wall here, and make a decision as to guilt or innocence. So that's the way it would normally work. You're doing it pretty close to the way we would normally do it. And normally we wouldn't have as many participants. There'd probably be just the lawyer and the defendant on one side and the state attorney, prosecutor on the other side. The state attorney for the 18th Circuit would normally designate one of his assistants to prosecute. And the defense can either hire a lawyer or the public defender would be assigned to that lawyer if the person is indigent. So that's the way it works, and I think you'll find that what you're doing this morning is fairly close to what actually happens. So with that, Colonel will.
Yes, sir.
Begin.
Defense, enter your plea, please.
I understand that the defense has a plea. Would you come up to the podium, please, and announce your plea? By the way, in a real court, there'd be a court reporter sitting here, and everything that's said would be taken down and recorded, but we don't have a court reporter today, so if you misstate, everybody will forget about it. You're lucky. Okay.
We plead not guilty by reasonable doubt.
Okay, the defendant has pled guilty by virtue of reasonable doubt. It will then be up to the state of Florida to prosecute the defendant and establish beyond a reasonable doubt that the defendant is guilty. Thank you. I believe the next, are there any pretrial motions that we need to resolve? Any pretrial motions?
No, Your Honor.
Does the defense have any?
No.
Okay. Opening statements. Prosecution wish to make an opening statement. While you're coming up to the podium here, let me just say that in real life, an opening statement is made by the attorneys, and it's designed to tell the jurors what they believe the evidence will show. It's not evidence in itself. It's simply like if you take one of these large picture puzzle things and you have a picture on the face of it to show you what the puzzle is going to look like when you get it all finished. And it's to give you an overview. So what is said now is not evidence. It's simply an opening statement. You may proceed, sir.
Your Honor, members of the jury, today it is my distinct pleasure to represent the prosecution of this case. My name is Austin Drury, and through my colleagues Warren Potter and Emma Trout and Lisa Smith. My colleagues and I are here today to prove that Barbara Barrett is guilty of murdering her husband beyond a shadow of doubt. We are confident that once you have heard our evidence, you will wholeheartedly agree with us. First, we will show Attributes of the testimony of Officer Cheney, a seasoned police officer, and the reporting officer that the victim's murder could not have been Lee Porter due to the shots being fired from the south side of the building. Next, through testimony given by Dr. Joe May, the pathologist, we will show you that the victim was fatally shot at a 45-degree angle face down on the floor. Our final witness will be Lee Porter. Through her testimony, we will reveal to you that on the day of the crime, prior to the shooting, Barbara Barrett was seen entering the house from the backyard after loud noises like the car backfiring were heard from the same location. Also, through her account of this traumatizing experience, we will show you that she was actually in the kitchen when she heard the 3 shots, and upon her going into the dining room to see what happened, she saw the terrified victim limping towards her with his trigger-happy wife behind him holding a gun. Once we have further expounded on this evidence, we have briefly mentioned, my colleagues and I are confident that you will agree with us by finding the defendant, Barbara Barrett, guilty of murdering her husband in cold blood.
Thank you, sir. Opening statement by the defense. Take a deep breath.
Your Honor, ladies and gentlemen of the jury, my name is Erica Duchesne, and I shall be making the opening remarks in this case. Please allow me to introduce my co-counsel, Abby Kennelly, and the defendant, Barbara Barrett. Her case is one of tragedy and heartbreak, but also one with many loops and holes in the evidence backing the claims of this heartbroken woman shot and killed her husband. It is these loops and holes that my co-counsel and I will help you scale today, so that, by the end of this hearing, none of you in this room will be able to call, beyond any reasonable doubt, Barbara Barrett guilty of murdering her husband. On December 18, 1988, the deceased, John Walker Barrett, came home in his usual late fashion to find his wife, Barbara Barrett, waiting a plate for him, like any loving, concerned wife would. Justly upset at his inconsiderate actions, she voiced her dissatisfaction to him as they sat in the living room. It was at this time when the deceased, indifferent to his wife's feelings, coldly informed her about his plans towards her. After dropping the heartbreaking news to his wife, they went into dinner, where they exchanged some more words. Despite Barbara's begging, he wouldn't reconsider or explain why he wanted a divorce. Confused and devastated, Barbara began to cry. And how did Mr. Barrett respond to his wife's obvious emotional turmoil? He told her to leave the room. Go away. Be gone. Confused and crying, Barbara did as she always does, and that is to please her husband. She abided by his wishes and left the room. She went into the living room and tried to figure out what she had done to make him want to leave her. A few minutes later, the deceased came out of the kitchen with a belt in his hands. Barbara Barrett will testify that besides being very afraid of her husband, this is all that she remembers. Ladies and gentlemen of the jury, it was only 5 days before that night that the deceased had deliberately beaten Barbara with a belt so severely that she was afraid for her life. Alas, this wasn't the only incident of abuse. Barbara Barrett will testify that her husband beat her 3 to 4 times a year, and sometimes so severely that she couldn't leave the house for days. The defense will use Dan McGuire, a practicing psychologist, who has testified in court before as a qualified witness on several trials, to prove the hardness of Barbara endured. He will testify using qualified research as to the reality of battered woman syndrome and its criteria. He will also testify that Barbara fits the criteria of a battered woman who has suffered years of abuse. The prosecution will call Officer C. James to the stand and attempt to portray him as a good officer. However, the defense will prove that he is an overworked, overstressed, sloppy cop who committed countless grievous errors and inconsistencies in the documentary and recording of the events of this case. Lee Porter, the Barrett's evening housekeeper, will also be called by the prosecution, who will use her testimony that she saw the deceased come through the house with a bloody letter to his paramour in his hands, chased by his wife with a gun, to prove the guilt of abused Barbara. However, the defense will bring to light her previous conviction of petty larceny and show, through the direct examination of Barbara Barrett, how Lee Porter was caught by the defendant herself stealing money from the deceased's private drawer. Lee Porter must have a big problem telling the truth. She claims that she saw the deceased running from his wife holding a bloody letter in his hand. This so-called letter is addressed to a nameless, unknown individual called Tipsy. Our client, Barbara Barrett, will testify that she never saw this letter, to which Lee Porter is claiming she saw in the deceased's possession. This Tipsy letter is only one piece of the puzzle, and we will show you exactly where it is. At the end of the day, when all the pieces of this puzzle are assembled, it will become clear that if anyone had the motive, means, or opportunity to commit this murder, it was most definitely Lee Porter. There were only 2 people present at the scene of the crime. The defense will show that Lee Porter is the one who the finger needs to be pointed at in making the conviction of murder. The prosecution is going to tell you a lot of stories today. Stories that will attempt to paint Barbara in an evil light, as a vengeful, spiteful woman capable of pursuing and murdering her husband. But today, when Barbara Barrett testifies, you will see a woman who stayed by her husband's side through years of physical and emotional abuse. Why, you may ask? Because in all this violence, she still saw him with kind, compassionate man she had fallen in love with all those years ago. She still believed her marriage was worth saving, and she was determined to do everything within her power to keep her husband's heart. There is not enough evidence to convict Barbara. Neither is there enough motive. Lady and gentlemen of the jury, when all this becomes clear, my co-counsel and I simply ask you to submit a verdict of not guilty.
Thank you, counsel. Prosecution's case, call your first witness.
Your Honor, the prosecution would like to call Officer C.M. Cheney to the stand.
Person in the courtroom. Come forward, please. Be seated in the jury box over here. Is the bailiff going to swear the witness? If not, I will. Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please be seated. You may inquire, counsel.
Would you please state your name and occupation?
My name is Officer Sam Cheney, and I'm an officer for the Milton County Police Department.
And how long have you worked for the Milton County Police Department?
For 7 years, since 1982.
What is your educational background concerning police work?
I graduated from South Bend College in Haddonfield, South Carolina, with a degree in criminal justice. I have also trained at the Police Academy and through personal experience to observe physical evidence of committed crime, to take measurements of physical proximities and blood on the case, and to interview witnesses, including suspects.
And you've had numerous opportunities to put these skills into effect?
Yes, I have.
Your Honor, I would like to request that Officer Cheney be recognized as an expert witness.
I grant your motion. She's recognized as an expert.
What division are you assigned to?
Counsel, an expert in what?
Criminal justice. Criminal, as a police officer who has...
Okay, go ahead.
Do you know on patrol alone or with a partner?
With my partner, Robson.
Was your partner with you on the night of the crime?
He was not. He was at home sick.
Now, what time did you receive a call about the shooting?
At approximately 9:50.
And how long did it take you to reach the crime scene?
About 7 minutes.
Is that a normal response time?
Yes.
Could you please state the location of the shooting?
2437 Ramblin' Woods Drive in the Glenmont area of the city.
And is that the Barrett's home address?
Yes.
When you reached the scene of the shooting, what did you do first?
Well, I was met at the door by the reporting reporter, who identified herself as the Barrett's housekeeper.
And what happened after she identified herself?
Well, I heard screaming somewhere in the house, but she pointed me to the living room, where I saw blood stains on the couch and bleeding all the way across bullet wounds to his back and one to the back of his head, and there was one to his back right thigh. There was also a big gun lying on the ground.
And he was, I assume, dead?
Yes, he was.
You filled out a police report on the crime scene, correct?
Yes.
Did you create any documents about the crime scene?
Yes, I did.
Your Honor, I would like to submit a diagram that Officer Cheney created into evidence as well as her police report.
There's a podium over there, and you put the diagram on it so you can show the jury. It's really not evidence, but you can use it as an aid to the testimony, understanding the testimony. So bring the podium back then. Bring it out here and put it where the jury can see it. Either one that works with your diagram. Please put it back when you're finished. Go ahead, put it up and down. Normally, in this courtroom, there's a big roll-down screen, and we have projectors over here and show them. I realize that may not be the easiest thing to see. Deal with it. Go ahead.
Your Honor, I would like to request that a magnified version be submitted.
A magnified version.
Yes, sir. I'll blow up with the original copy.
Well, I'll grant that. Do you have any equipment to do that with? You're just using it as an aid to the testimony, so go ahead. Is there any objection on the part of the defense?
No, Your Honor.
Okay. I'm sorry that you all can't see it, but we'll deal with it. Go ahead.
Officer Cheney, are the diagram and police report that you filled out completely accurate?
There's a back door exiting through the kitchen in the house that should be on there, but I omitted it. And the belt you see lying on the floor of the living room is next to the jacket, but it's actually on top of it.
And in your police report, are there any errors?
Well, there was a typo that said, was the killing was stranger to stranger? It said yes, but it was not. It should be no.
Now, would you mind if I repeat your walkthrough of your dining room on the diagram?
Yes.
Your Honor, may the witness step down to follow the elevator.
With a pointer. Explain your testimony by using that diagram.
Now, before we go any further, could you please describe the measurements of the living room?
Well, the room was square and it had a length and width of 60 feet.
Now, you entered the room at the entrance, correct?
Yes, I did.
Objection, main question.
Rephrase your question.
Could you please show the jury where you entered the house?
I entered the house here at the entrance.
And what did you first notice when you entered the room?
Well, I noticed that there was large blood stains on the ground. There was also an envelope lying on the floor next to sofa number 1. And there was a jacket and a belt lying on the floor.
Now, was the jacket on top? Was the belt on top of the jacket?
Yes, it was.
But in your diagram, it shows it right next to it. Could you please explain why?
Because if I had drawn the belt on top of the jacket, it would have hit there. Since they're both black, it would not be able to see it. And my job is to present all the evidence.
The envelope on the floor was already open, correct?
Yes.
Objection, main question.
Sustained. Your question is leading.
Was there an envelope on the floor?
Yes, there was.
And what were the contents?
It was empty.
What was the intended recipient's name on the envelope?
The name was Tootsie.
And what were the contents of the envelope?
There was a letter that had been crinkled up and soaked in blood and that I had found in the deceased's right hand.
But it was not with the envelope?
No, it was not.
have been fired from the south side of the living room?
Yes.
As a police officer, you're familiar with guns and shooting targets, moving or otherwise, correct?
Objection, leading question.
I'll overrule that. You go ahead and answer the question.
Would you say it's harder to hit a moving target at, say, 15 to 20 feet than when they're motionless in front of you?
Yes.
There was a lot of blood throughout the room, correct?
Yes.
Objection, leading question.
Okay, you're asking leading questions. Try to say, was there blood on the floor is a legitimate question, but say there was a lot of blood on the floor, wasn't there? That's leading.
Was there a lot of blood on the floor?
Yes.
Now, in your diagram, there is a sizable blood stain on the back of the couch, 2 smaller splashes in front of the sofa and on the floor, and 5 more blood stains varying in size which create a trail of blood leading into the dining room. Are those accurate?
Yes, they are.
Some blood was smeared on the door leading into the dining room as is shown in your diagram, correct?
Yes.
Finally, when you entered the dining room, you said that you came upon the body of John Walker Barrett lying face down in a pool of his own blood with multiple wounds to the back.
Yes.
According to your training and experience, would these bloodstains be consistent with the victim being shot while sitting on the sofa, fleeing from the room while being shot at from behind, and finally being followed into the dining room and receiving the final
Objection,
fatal
question
shot?
restates
Wait,
the.
let him finish his question before you make your objection, and I'll rule on it.
According to your training and experience, would these bloodstains be consistent with the victim of being shot while sitting on the sofa, fleeing from the room while being shot at from behind, and finally being followed into the dining room and receiving the fatal shot to the face of his brain?
Yes.
Wait. And you still have your objection lodged. I'm going to sustain your objection. Don't ask a whole series of facts like that for the person to answer. Ask the facts one at a time.
Before making a detailed investigation of the crime scene, did you attempt to locate any suspects?
Yes, I did.
And did you find any?
Yes, I found the defendant Barbara Barrett screaming and crying because she had locked herself in the downstairs bathroom.
Was this the source of crying and screaming that you heard when you first entered the house?
Yes.
Were you able to comprehend anything that she was saying?
She said things like, I didn't mean to hurt John. Why'd you get to hurt me so? And why'd you get to leave him?
Now, did she exit the bathroom after you warned her of your duty to capture any suspects?
Yes, she did. She unlocked the door, came out, and she promptly collapsed.
And when you informed her of your duty, did you make it clear to her that your duty was to reach her even if it entailed breaking down the door?
Yes.
So that's within your duty, correct?
Yes. Objection, Your Honor. Leading question.
Overruled.
Now, what happened after she exited the bathroom?
Well, it took several minutes to revive her after she collapsed, so I called for a doctor and I sat her down at the table in the kitchen.
When you finished investigating the crime scene, did you escort Mrs. Barrett to the police station?
Yes, I did.
Is it true that you informed Mrs. Barrett of her Miranda rights multiple times on that issue?
Objection, leading question.
The question is, did you inform this woman of her Miranda rights?
Did you inform
You
Mrs.
can answer
Barrett?
the question.
Yes.
And you can ask how many times did you do it?
How many times did you do it on the issue?
At least twice.
Did you also obtain a statement from the defendant?
Yes, I did.
Your Honor, may I submit the statement obtained for recognition by the witness?
We'll say the defense.
We have no objection to that statement.
All right, ready to show it to the jury if you want to. What is it, the statement that you want to get into evidence?
Yes, Your Honor.
Let me see it first.
Officer Cheney, is this the statement that you obtained from the defendant?
Yes, it is.
And she signed it in your presence?
Yes.
Did you allow her to read it multiple times before signing it?
Yes.
Did you ever, on the night of the shooting, threaten, coerce, or force her?
I did not.
Did you tell her that she would be given any benefits if she signed the statement?
No.
And did you hinder her from contacting anyone?
No, I specifically remember her calling her sister and her lawyer.
Did you inform her that the questioning could be discontinued at any time?
Yes.
Thank you.
You want to publish that to the jury, admit it in evidence, or they, I think they've already seen it, so. Want to bring that document up here to the bench, and I'll keep it up here as a defendant, or as a prosecution exhibit 1. Thank you, you're finished with your testimony, you're excused. Normally, we would have a clerk that would stamp these exhibits and keep them straight. You'd be free to take them into the jury room with you when you go. Call your next witness.
Excuse me, Your Honor? Do we get to cross examine?
Yeah, where's your witness? I'm getting ahead of myself, thank you. You may cross-examine, I'm sorry, I need to cut you off.
You were the reporting officer for the scene of the shooting, is that correct?
Yes, it
Is it also correct that you tagged the evidence
is. Yes.
and that you drew up a scene diagram?
Yes.
Your Honor, the objection to the attorney's leading witness.
Overruled. You can ask leading questions on cross-examination.
And then you drew up a scene diagram?
Yes.
Is it also true that you documented an incident report?
Yes.
And you think that you were completely thorough in your investigation?
Yes, I do.
And that your diagrams and reports are accurate down to the minutest details?
Yes.
Can you please point out the back door of this house on the side?
It should be.
Wait.
It should be located here in this building, but I abandoned it.
Why did you?
I did not find it. That is not part of the stipulated facts.
Alright, so did you mark the private door on this diagram? Or did you omit that?
I did not.
You did not mark it? Okay.
That is not.
You found a gun next to the body of John Barrett, didn't you?
Yes, I did.
And it had 6 spent rounds?
Yes, I did.
5 bullets from the gun struck the deceased, correct?
Yes.
And isn't it true that you found the 6th in the wall?
Yes.
According to the pathologist, only 3 bullets were found in the deceased, although as I repeat, 5 bullets hit him. Do you agree that there are 2 bullets that hit the deceased and yet were not found in him?
That is another part of my expertise.
Did not. Alright. Did you mark 2 bullets on your diagram? Along with the one found in the wall?
No, I did not.
You did not. You lost 2 bullets? Or you just omitted them?
That is not part of the stipulated facts.
Alright. You have 2 daughters,
Yes.
age 3 and 5.
Yes.
Your hours of duty are from 4 p.m. to 12 a.m. Tuesday through Saturday.
Yes, they are.
And yet you also work another job on your off hours.
Yes.
Your off hours being from 1 a.m. to 3 p.m.
Yes.
You usually ride as a partner, is that correct?
Yes, I do.
But on the 18th of December, your partner was ill, right?
Yes.
So on that night, all night, for about 6 whole hours, you were working all alone.
Yes.
And you believe, do you not, that you read Mrs. Barrett's Miranda warnings?
Can you please repeat the question?
You believe, do you not, that you read Mrs. Barrett's Miranda warnings?
Yes, I do.
Even after working a long shift, alone, and dealing with the shooting, you do believe that you did.
Yes, I do.
But you cannot recall the act, can you?
I do not recall the exact time, but I do remember.
You do not remember a specific recollection of reading her Miranda warnings.
Yes, she was.
That is to say, she was screaming and crying.
Yes, she was.
And you threatened her, didn't you?
I did not.
Didn't you tell her you would break the door down?
Yes, I warned her.
And you don't count that as a threat?
No, I do not.
You do not count threatening to break the door down as a threat. Because she would not get hurt when the door was broken down.
I warned her that it was my duty to.
Please answer my question.
No.
She would not get hurt when the door was broken down.
What was your question again?
That Barbara Bear would not get hurt. Would Barbara Bear have gotten hurt if the door had broken down?
That is not part of the stipulated facts.
Objection, Your Honor. The attorney is asking a hypothetical question.
He's asking a hypothetical question. Oh.
You still don't count breaking the door down as a threat.
No.
Alright. After you threatened her to break the door down, she opened the door right away, didn't she?
Yes, she did.
And then immediately collapsed on the floor.
Yes.
And then it took several minutes to revive her.
Yes, it did.
And she was so distraught that you even had to call in a doctor to attend to her, didn't you?
Yes.
You took Barbara into custody less than 10 minutes after this, right?
Yes.
And you accused her of murdering her husband at this time.
Yes.
And then you took a statement from Barbara at 10:53, correct?
Yes.
When her husband had died less than 40 minutes earlier?
Yes.
Don't you think the whole process might have been upsetting for her?
I don't think so.
Was she distressed?
She's indeed.
She was still lucid, wasn't she?
That is not a part of the stipulated facts.
But a suspect has to be lucid to give a statement.
Yes.
She was lucid. She was in the right frame of mind.
Yes.
After her husband had died, 40 minutes previous, you threatened his violence. She was so distraught that you had to call a doctor to attend to her. And then you accused her of murdering her beloved husband. She was thinking one.
Yes.
I see. Mr. and Mrs. Bear were husband and wife, weren't they, Mr. Shaney?
Yes, they were.
I suppose that they were acquainted, yes?
Yes.
Which makes them not strangers to a stranger, correct?
Yes.
You filed on your incident report that the Bears were strangers, didn't you?
Yes, I did.
When they obviously were not. When they obviously were not.
They were not strangers.
No further questions.
You're free. Step down. Next witness.
Your Honor, I would like to call Dr. Davis to stand.
Is he here in the courtroom? She? He or she is in the courtroom? Please come up on the witness stand. Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. You may be seated. You may be seated. Correct.
Could you please tell the court your name?
My name is Dr. Hill.
What is your current profession?
I am a pathologist from Wilson County.
How are you involved in this case?
I performed the autopsy on John Walker Bear.
Your Honor, I would like for Joe Armade to be presented as an expert witness because she was involved in the autopsy.
Well, she's not an expert because she was involved in the autopsy. She's an expert because she's a pathologist, so we'll let you testify as an expert.
Who authorized the autopsy?
The lawyer John Smith.
Did you create a drawing of your autopsy results?
Yes.
Your Honor, I would like to enter into evidence this enlarged diagram of the autopsy.
You may take that one on the other side of your way or put it behind the one you're putting up there.
May Dr. May please stand to and refer to her diagram.
She may.
Thank you. Could you please describe the appearance of the deceased to us?
The body was a well-developed, well-nourished. He was a middle-aged male, dressed in a white button-down shirt, a tie, blue-gray suit pants, black wingtip shoes, and black socks.
The body is 74 inches tall, which is 6 feet 2 inches, and he weighed 184 pounds.
During the autopsy, how many gunshot wounds were found on the body?
5.
Where are the bullet wounds located?
There is one gunshot wound to the upper portion of the left arm, from front to back, through and through, meaning that it enters in the front and exits in the back. There are 2 gunshot wounds to the back, slightly to the right of midline, from back to front, at an approximate angle of 45 degrees from the horizontal plane. There is another gunshot wound to the upper portion of the right leg, from back to front, through and through, meaning that it entered from the back and exited from the front. The last gunshot wound is to the posterior portion of the cranium, which is the back of the head.
Could you detect whether or not the bullets were shot from the same gun?
That is not part of the stipulated facts, but all the wounds contain the same size caliber.
What was the cause of Mr. Barrett's death?
The gunshot wound to the posterior portion of the cranium was the cause of death.
Can you determine what angle the bullet was shot?
Are you referring to the wound to the head?
Yes, I am.
It was shot at a 45-degree angle.
Were there any powder marks on any of the wounds?
No.
What does the lack of powder marks on any of the wounds mean?
The lack of powder marks would mean that the muzzle of the firearm was more than 2 feet away from impact.
Could you please describe the cranium to us?
There is a tear of skin that is 5 centimeters long that extends diagonally across the posterior portion of the cranium. And the posterior cranial cavity is fragmented, which means part of the skull was shattered. Within the cranial cavity are 2 fragments of bullets, and no pre-existing abnormalities are apparent, meaning that there wasn't any physical wounds on the body before the incident.
So what you're telling us is that he was shot here and here, and that he must have been lying on the floor face down in order for the shooter to stand over him and shoot him twice in the back and once on the
Objection, Your Honor.
of the cranium.
Let me finish. What's your objection?
The question states favorable facts to the opinion of the Constitution.
I'm sorry, run that by me again.
It's restating favorable facts.
Oh, what's your objection?
That the shooter had to stand over the body in order for the person to shoot him here, here, and here at a 45-degree angle from the horizontal plane, correct?
Yes.
Objection to your question.
Overruled.
No further questions, Your Honor.
Cross-examination?
Is it true that you did not know which order the shots were fired?
Yes.
So the shot to the head was not necessarily the last shot fired.
Can you please repeat the question?
The shot to the head was not necessarily the last shot fired.
Well, when he was shot, he was on the
Could I have
ground.
a yes or no to that question?
Can you determine whether the last shot fired was the one that hit him in the head? Is that your question?
Yes.
Can you answer that, yes or no?
And you cannot tell us the same person fired all 6 shots.
Yes.
You can tell the same person fired all 6 shots.
Yes.
How can you tell?
No.
You cannot tell.
No.
So you cannot tell the same person fired all 6 shots.
No.
So it's possible that 2 separate people could have shot down here.
No.
It's not possible?
No.
It's not possible at all?
Your objection, repetition.
Well, it's argumentative. And rephrase your question.
not set in stone that the same person fired all 6 shots. Is that correct?
Yes.
So it's possible that 2 separate people could have shot him.
Yes.
Is it possible that there could have been a pause in between the first 3 shots and the last 3 shots because of your inability to tell in which order the shots were fired?
Yes.
You found 3 bullets in the deceased. Oh, I'm sorry. The police, not you. You found 3 bullets in the deceased. Is that how many wounds he has?
No.
How many wounds does he have?
Yes, 5.
So you agree that Officer Cheney lost 2 bullets?
Can you please repeat the question?
You agree that Officer Cheney lost 2 bullets? That's only 4 bullets.
Are you saying how many bullets were inside the body?
3 bullets were inside the body.
Yes.
Yes. 1 bullet was found in the wall. There are 5 bullet wounds and 3 bullets in him. Do you agree that Officer Cheney lost, misplaced the other 2 bullets?
Yes.
No further questions, Your Honor.
Okay. You're excused, you step down.
Your Honor, the bailiff is going to assume his position over on the side, and you'll handle the swearing in of your position.
Okay. Next witness.
Your Honor, the prosecution would like to call these orders to the scales.
May you come forward, please?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
You may proceed.
Will you please tell the court your name and current profession?
My name is Lee Porter.
Objection, Your Honor. Compound question.
Huh?
Compound question.
Restate your question.
What is your name and current profession?
My name is Lee Porter and I'm a housekeeper.
That isn't the question, but go ahead and answer the question. Speak up a little bit, please.
How long have you been a housekeeper?
My whole life.
Were you the Barrett's housekeeper?
Yes.
How long have you been a housekeeper?
The past 6 months.
What were your normal work hours?
2 to 10 p.m. Wednesday through Sunday.
Would you consider the Barrett home a happy home?
No.
Objection, Your Honor. Opinion. Please make your opinion which is not necessary.
Overruled.
Did you ever see Mr. Barrett hit his wife?
No.
Or any bruises on Mr. Barrett?
No.
So you've never seen Mr. Barrett hit his wife or any bruises on Mr. Barrett?
No.
Were you working on December 18th, 1988?
Yes.
Had anything unusual happened earlier in the day?
Yes.
Did you explain?
Well, I heard 3 loud noises right after I came into work. And later, a few minutes later, I saw Miss Barrett coming in through a private entrance in the kitchen we usually don't use, holding a gun in her hand.
Were you frightened?
Yes.
Have you ever seen Miss Barrett with a gun before this?
No.
About that night, about what time did Mr. Barrett come?
About 9 o'clock.
Was it unusual for him to come home that late?
No.
Where did he first go after entering the house?
He said his brake came down and went into the living room.
Did he do anything there?
He poured himself a glass of scotch and sat down.
Had Mr. Barrett been drinking that night?
No.
Did he ever drink?
Yes.
When you went to announce that dinner was ready, how did the Barretts appear?
Very angry, like
What did Mr. Barrett tell Mrs. Barrett when they began meeting?
Sustained the objection that is hearsay. Or calls for hearsay.
At this point, could you describe Mrs. Barrett's emotional state?
She's crying hysterically.
At dinner, did Mr. Barrett tell Mrs. Barrett to go anywhere?
Yeah.
Objection made in question.
Overruled.
Did Mrs. Barrett listen?
Yes.
Did she have any departing orders?
You'll be sorry.
Did you witness the shooting of Mr. Barrett?
Yes.
When you went into the living room to investigate, did you see anything?
Yes.
Did Mr. Barrett have anything in his hand?
Yeah, a bloody letter.
Could you describe what it was?
Terrified.
What happened next?
He came into the, I heard 3 loud noises coming from the living room. I ran into the dining room to see what had happened, and I saw Mr. Barrett coming around the corner of the dining room. He looked terrified. He had a bloody letter in his hand and he was moving. He was bloody all over. And after he turned the corner, I saw Mr. Barrett coming.
Objection, narrative answer.
What is your objection again?
Narrative answer.
Overruled.
I saw Mr. Barrett coming after him with a huge gun.
What did you do when you saw this?
I ran out of the house.
When did you return?
About 10 minutes later, but I was with TV track. I was so scared.
When you arrived back at the house, where was Mrs. Barrett?
She was sleeping in the downstairs bathroom.
How did you know it was her?
I could recognize her voice.
What was she saying?
Objection, Your Honor. Hearsay.
What is the basis of your objection again?
Hearsay.
What?
Hearsay.
Overruled.
Could you repeat that question?
When you found Mrs. Barrett, what was she saying?
I left him wiping his with me while the safety after her was down as I waited for her call.
Did you let the police officer?
Yes.
By the way, have you ever been in any trouble with the law before this?
Yes.
Did you what?
My past employer accused me of stealing $100.
What did you plead?
Guilty.
What were the results of this?
It was a plea agreement, and I pled guilty and I took obligation.
That's all I remember.
Cross-examination.
You testified that you claimed you heard Barbara say something like, "You'll be sorry," did you not?
I did.
Are you absolutely sure that's what you allegedly heard?
Yes.
You're absolutely sure?
Yes.
Are you aware that your testimony says that you are not absolutely sure?
Yes. Wait. No. Your Honor, that's just like what we were saying.
You gotta abide by the fact statement that was given to you, so you want to answer the question again, ask the question again and answer.
Are you absolutely sure that that's what you allegedly heard?
No.
You're not absolutely sure because you were walking into the kitchen when you heard it, right?
Correct.
There's a breakfast room between the kitchen and the dining room, is there not?
There is.
So there was at least one room separating you from the Barretts at the time you say you heard that, wasn't there?
Yes.
Could you please point out on the diagram where you were located when you allegedly heard Barbara say these words?
Can I please refer to my witness statement? I don't know.
Raise your question.
Could you please point out on the diagram where you were located when you heard
I was
Barbara say?
going into the kitchen.
Could you please point that out on the diagram?
Please.
Step down from the witness box and point it out to the jury, please.
Permission to leave the podium?
Huh?
Permission to leave the podium? You need to from the living room, correct?
Could you please repeat the question?
After you heard the 3 shots, you supposedly saw the deceased limp into the dining room from the living room,
I did.
and you allegedly saw Brother Barrett chasing him with a gun.
I did.
During direct examination, you said that you saw Barbara shoot the deceased, correct?
Correct.
Are you aware that your statement does not say anything about you seeing her shoot him?
I was not. I was not, but I am now.
So your answer is?
No, yes.
But you're aware that
Could you please repeat the question?
are you aware that your witness statement says otherwise?
No, I was not.
So you say you heard gunshots and supposedly saw a bloody limping man followed by a maniac with a gun, right?
Correct.
That must have been a terrifying sight for you to see. You became so afraid you ran out the back door in fear, didn't you?
Yes, that's terrifying.
You must have been afraid for your life, weren't you?
I was.
So, you fled from the scene in terror. But isn't it true that only minutes after you fled from the scene, you returned?
10 minutes later.
But weren't you afraid for your life?
I was.
So you came back before the police arrived. Is that right?
I let the police officer in.
But you were there before they arrived,
It's
right?
not listed in the facts.
In your statement, you said that you were there before the police arrived. Isn't that correct?
Where's there?
You were in the house before the police arrived,
It's not listed in the facts.
but it's in your statement.
It says that I let the police officer in.
No, it's not.
Okay?
Would you like to read your statement?
Yes.
Permission to show.
You may show her statement. This is a statement that's part of the evidence rather than a fact statement that she was given to prepare for. What is the nature of the statement? Is it part of the fact statement that you're given, or is it part of the?
I'm just trying to get the right answer out of her that I believe.
Okay.
And she is going on.
Permission to approach the
You
witness.
may.
On the paragraph, could you please read my sentence?
There was blood all over. I didn't see nothing more until about 10 minutes later when I came back before the police officer arrived.
Thank you.
And the jurors hear her answers.
No?
Please speak up. Both of you need to speak up.
All right.
Makes you feel any better. I have the same problem I have with the religious thing.
So your witness statement says you were there before the police arrived, correct?
Yes.
But before you just stated that you weren't there before the police arrived.
Yes.
So it is true that you were all alone with a mad woman shooting a gun, weren't you?
It's not even, yes, or no.
Please answer yes or no.
Yes.
Your fear must have gone away really quickly for you to be brave enough to go back to the scene and face the world with a gun, don't you think?
I bet. Yes. Yes.
Or could it be that you had to return to the scene to fire the last